Canyon from Golden to Wyoming, damage is widespread.
A Plaintiff's Guide to Protection from Abuse Cases in Maine. Getting help with the court process.
Hello, I'm an attorney at Pine Tree Legal Assistance. I help victims of domestic violence when they are asking the court for orders of protection. If you've decided to file a complaint to get an order of protection, you may be able to get help from your local domestic violence agency. They can help you fill out the paperwork, explain to you what will happen in court, and help you make a safety plan. You can get contact information about your local domestic violence agency from the clerk at the court or from the Pine Tree Legal Assistance website.
Representatives from your local domestic violence agency can help you file a complaint with the court. To locate a domestic violence agency, call the statewide domestic violence hotline, 1-866-834-HELP. Use this link to find a local helpline number. Or ask your circuit court clerk or Pine Tree Legal Assistance for a referral. Filling out the complaint form.
If you are the plaintiff and have decided to fill out a complaint, there's a section where you have to write down what's happened to you and why you need protection. Start by putting down what your relationship with the defendant is or was. Are you married? Are you partners? Were you living together, or did you have a child together? Or were you in a sexual relationship? Then write down the incident that led you to ask for protection. Describe what happened. Don't just put that you were physically abused or threatened. Be specific. If you were hit or slapped or pushed up against the wall or forced to do something against your will, if you were prevented from leaving or prevented from asking for help, write that down. Then put down if you've ever been abused by this person in the past. If you were physically abused or threatened, you can write that down, but then give some examples, either of the worst thing that happened or the most dangerous time that you can remember. If the defendant has been arrested for hurting you, write that down as well. If your children have ever been abused or were present during the abuse, put that down and give some examples. You don't have to write down every detail of your relationship. For some people, a paragraph will do. Some people may have to add 1 or 2 pages. The important thing is to be clear and be specific so the judge can understand what happened to you and why you're asking for protection.
As you fill out the complaint form, describe your relationship with the defendant. Be clear and be specific about what happened to you. Let the court know if your children witnessed the abuse, or if the defendant has abused the children. Let the court know if the defendant has a history of hurting you. What to do if you are not granted a temporary order of protection?
If you are not granted or do not ask for a temporary order of protection, you will still be given a hearing date within 3 weeks when you can come back to the court and ask for a long-term order. If you do not get a temporary order of protection, the responsibility of making sure that the defendant is served with your complaint and with notice of the hearing is your responsibility. To do this, you have to go to your local sheriff's office and give them the paperwork. You have to ask them to serve the paperwork on the defendant. Once the sheriffs have served the defendant, they will sign a piece of paper saying that the service has been made. Some sheriff's office will return this directly to the court. Others will return it to you. You should ask the sheriff what will happen with this signed paperwork saying that the defendant has been served. You have to make sure that this paperwork gets back to the court. The court has to know that the defendant has been served, and they have to know that in writing.
If you do not receive a temporary order of protection, it is your responsibility to bring the court paperwork to your local sheriff's office so they can serve it on the defendant. Make sure that the court receives written confirmation that the defendant has been served. The final order of protection.
Whether the final order is agreed to or granted after a hearing, the judge will want to make sure that the plaintiff is properly protected, and some plaintiffs may want to have no more contact with the defendant. However, a final order can be written to take into account a particular situation. For example, if the plaintiff and defendant are married, the order can provide for visitation, safe drop-off and pickup, and contact, perhaps phone contact, between the parties so that they can talk about the children. The order can also provide for child support and some division of personal property. The final order can last for up to 2 years, and if circumstances change during that time, either the plaintiff or the defendant can ask the court to modify or change the order in writing.
The order of protection can be written to meet the needs of your specific situation. It can provide for child support and some temporary division of personal property. It can last for up to 2 years. Either the plaintiff or the defendant can ask the court to modify the order if the situation changes. Criminal charges against the defendant.
If the defendant has been arrested, there may be criminal charges pending. These charges are brought by the state of Maine and are prosecuted by the DA. The plaintiff may be a witness in this case, but the plaintiff is not bringing those charges. The protection order is a civil case. The plaintiff brings it in civil court. The judge in the protection order hearing may not know that there are criminal charges pending against the defendant. You should tell the judge. If the defendant has bail conditions that allow for no contact between the defendant and the plaintiff, and there's a protection order that allows for some contact, for example, phone contact, that contact cannot happen until the defendant's bail conditions have either ended or been changed.
You should tell the judge if the defendant has been arrested or is subject to criminal charges, or if the defendant is subject to any bail conditions that might affect your protection order.